call. Yes. Just kind of looking through this petitioner's motion to modify the order. Yes. From 10:2 to 10:12. Yeah. Motion hearing. I wasn't given notice of that. Oh. Order issuing temporary protection order. 14 days later. Yes. I don't know as I got anything on that either. Oh. Sheriff's return of service, but I'd like to look at those returns of service. Yeah. Because for every time that you did not give me notice and the actual number of days as required by law, you made it difficult for me to arrange to be there. Those 5 judicial days, they say sheriff's return of service on 10/16, but that would have been the day of the motion hearing. Yes. Was that 5 judicial days before? You would think the sheriff's return of service would have been in the file. Yes. At least 5 judicial days before the court hearing. I mean, you're out there, you're serving people, you go back to the sheriff's department, you hand it to the secretary. She hands it off to the court clerk and you put it in the file. But you decide to drive around for 10 days looking for me and then, oh my gosh, we only gave him 1 day notice. Now, I think this is a big one. Yes. Exactly what do you do when it's the moving party? Right. What do you do when it's the responding party? Yes. What do you do when one of them doesn't appear there, known as the moving party? You deny it? Yes. Or you strike it from the court record, or quite possibly both. I don't know exactly how it works. Yeah. And then what do you do if the respondent doesn't appear? You usually give them what they ask for, don't you? Yes. But what if both of them don't appear? What do you do, Brent? You don't issue the fucking thing. Now, I'm wanting my sons and I'm wanting to sue you. Not just this county and Jefferson County, but the state of Washington and every state that I've emailed. Oh, seems like they really don't enforce the law. In fact, I got an email from a guy in Iowa that I probably had emailed him. He had said something about expense. Yeah. But I thought it was fraudulent, so I included the Attorney General of Iowa and the Executive Director of the State Bar Association of Iowa. Now, somebody wasn't fucking around trying to cause me some concern because I couldn't open it. There's a failure to appear. If the party noting a motion fails to appear for the scheduled hearing, and the opposing party appears, yes, the motion shall be denied. Every time you did not give me notice, inclusive of the required number of judicial days for the last 7 years and almost 3 months now, yes, you gave the opposing party the right to appear without me being there. Yes, and if she didn't, I wouldn't know it, would I? No, you wouldn't know because I wasn't there. So I would say for every time that you had a motion hearing without me being served, temporary protection orders, yes. Orders reissuing, yes. Orders for permanent protection orders, yes. Inclusive of modifying orders, yes. You deprived me of the possibility of the other party not being there so as to have you deny it. Now, it might not seem big to you, but I think it's a big one. It's like in the billions. I think it is. This is such a simple rule, but the failure, right? The refusal, the inability, the rendering criminal assistance to violate civil rights, yes. Custody rights, terrorist, conspiracy, combination, treason, child abduction and exploitation, possibly grand larceny. Then there's that whole big question of have you been betting on court hearings? Yes. You kind of are not really fair in your legal gaming. Yes. See, if you give me notice, you know I will appear in court. Yes. And that would kind of not be fair to the rest of the gamblers. It's easier to just send it to Kitchen Dick Road, that happens to be the husband of the woman that I want to have sex with, that happened to use an image of my sister in a photograph holding Regina. Yeah. Now, did Mike Van Proyen bet on it? Did he bet the farm? Pop, pop. Now, for all of this racketeering, yes, yes, in the come to find out family of the top secret way of betting on court cases, I think it's a big one. See, let's say you're a gambler. You're going to bet the farm. And everybody says, well, Paul always does what the law requires because I have. Yes. But he won't do what the law doesn't require. But the judge is corrupt enough to issue a failure to appear so that you can win because Paul didn't get notice of court hearings. Now, when Paul doesn't get notice of court hearings, you, the court, have really screwed over a lot of people over the last 7.5 years. Yeah. Because you know how smart the dogs are. Yes. They believe everything you say. Lizard brains. Oh my gosh, that's so funny. Oh, cute. You know, when you shit the shit through the mind of a lizard, that happens to be in your ass. They read it and they laugh their ass off. I'm gonna make so much money. Now let's say you arrest me for this 4 days later, pooch, on the 4th of January, and you only pay for the shows that where I get arrested. Yes. And this says, oh, failure to appear. Now, I told the police department, I said, you have no jurisdiction, and they didn't want to listen. I told Judge Porter, I said, Judge, I didn't receive any personal service or service by publication, but he didn't want to listen. He doesn't have jurisdiction to remove a protection order where the court rules would say if the party motioning fails to appear, the petitioner, yes, because she didn't sign it, should have been denied or stricken. Now, exactly how much jurisdiction does it take to enforce court rules? Not like you're enforcing the jurisdiction of the state of Washington. I noticed that each county has their own court rules. They have superior court rules. Yes. Now, let's say it's a district court issue. Of all the times that somebody motioned to district court, yes, criminal or civil, I don't know exactly which one. And the individual known as the party noting a motion fails to appear, how many times have you issued a court order without the appearance of the motioning party? Now, if the moving party appears and the opposing party does not appear, the request of relief, judge, okay, jurisdiction. You can issue it if it's warranted, isn't that right? But it requires the actual appearance of the moving party. Oh. And then there's that big question that all the judges ask themselves, right? Exactly what jurisdiction do you have to remove a court order where neither party appears in court?